Now, I'll kindly request Honorable Chief Justice of India, Justice DY Chandrachud, for the address.
Ms. Anna Jobin Brett, Secretary of UNCITRAL, Mr. Marcin Chapelak, the Secretary General of the Permanent Court of Arbitration, a very distinguished sister, Justice Indu Malhotra, former Judge of the Supreme Court of India and member of the Permanent Court of Arbitration, Justice Sanjeev Khanna, Judge of the Supreme Court of India, my sister and brother judges from the Supreme Court, Chief Justices of the High Court judges, Mr. R. Venkatramani, Attorney General for India, Mr. Kapil Sibal, President of the Supreme Court Bar Association, President of the Supreme Court Advocates on Record Association, all the office bearers, all the distinguished judges of the High Court and members of the global arbitration community who have assembled here this evening. This conference, as we've heard from different speakers, marks a significant milestone for two towering institutions, the Supreme Court of India and the Permanent Court of Arbitration. At our birth, the Permanent Court of Arbitration was getting into her middle ages. At 125, you have to reinvent yourselves, and the cells have to regenerate. I think we are following in close tandem in the Supreme Court. We are regenerating and reinventing ourselves, whether it's in terms of access to justice or in terms of the adoption of technology or the creation of new infrastructure for our court. As the Supreme Court celebrates 75 years of its establishment, and the Permanent Court of Arbitration celebrates its 125th anniversary, we couldn't have had a better occasion to do something together, which is the launch of the PCA office in India. Well, time has tempered both our institutions, testing their mettle from time to time, with both institutions proving their enduring commitment to the rule of law. The PCA has organized 5 events in India, including one capacity-building training program organized in collaboration with the Ministry of External Affairs. I'd like to take this opportunity to thank the MEA and its secretary, Mr. Damu Ravi, who has really been very personally involved in this whole movement of training and evolution. I've had the distinct privilege of being a part of these events. But today's milestone conference marks a palpable sense of void. Mr. Fali Nariman, an eminent senior counsel and a doyen of the global arbitration community, passed away in February this year. Not only has the Indian legal community suffered the profound loss of a beloved lawyer, jurist, and mentor, but the global arbitration community too has lost a towering spirit and figure. Mr. Nariman was the ultimate multi-hyphenate, if I may call him so. He was the ultimate multi-hyphenate of the PCA as a council, appointing authority, and passionate advocate for its outreach efforts in India. Notably, Mr. Nariman played a key role as counsel in the PCA-administered Indus Waters Kishanganga arbitration between India and Pakistan. This case is truly heralded as a masterclass in using arbitration to resolve even the most sensitive and contentious disputes between nations with delicate relationships. There's nothing as delicate as the sharing of waters. Mr. Nariman was also the chief architect of the outreach efforts by the PCA and independent organizations such as the International Council for Commercial Arbitration in India. He served as a president of the ICCA between 1994 and 2002. Mr. Nariman is often credited with activating the host country agreement between PCA and India by spearheading the organization of the PCA India conferences. In fact, the vision to host an event celebrating the 125 years of the PCA was conceived by and championed with Mr. Nariman at the helm. Today we are realizing his shared dream, though unfortunately without his physical presence. Until the night before Mr. Nariman's passing, he was grappling with arbitration law and working on settling a draft written submission for a constitution bench hearing in the Supreme Court on the subject. Coincidentally, This is a case about arbitrator bias, which the Supreme Court reserved for judgment just a couple of weeks ago. Throughout his life, Mr. Nariman spoke with a candor that was as refreshing as it was terrifying. Who else could make you laugh while simultaneously pinning you to the wall with a piercing question? I vividly recalled his address at the UNCITRAL South Asia Conference held around the same time last year. In his characteristic style, he fired off a series of piercing questions that the Indian arbitration community continues to grapple with and find answers to. In many ways, this conference is an attempt to pay homage to Mr. Nariman by doing what would have brought him the greatest joy, relentlessly pursuing answers to the tough questions of our times and fearlessly asking new ones. The theme of this conference, International Arbitration and Rule of Law, is particularly significant. The arbitration community across the world often emphasizes the importance of commercial efficiency and ease of business, but these values are inextricably linked to a deep respect for the rule of law. Put simply, the rule of law heralds better economic and commercial outcomes. Respect for the rule of law promotes fairness, stability, and predictability. This in turn creates a conducive environment for economic growth, as investors thrive in a system where rights are protected, contracts are enforced, and disputes are resolved efficiently. A strong rule of law framework also encourages foreign investment, promotes trade, and enhances a nation's global competitiveness, ultimately driving sustainable economic development and improving living standards. The rule of law shares a symbiotic relationship with the creation of an environment which fosters economic stability and growth. Rule of law principles are, in other words, the virtual semiconductors of our digital era. The time has come for India to take the lead in fostering a culture of international arbitration, providing a level playing field for dispute resolution beyond domestic courts. And not without reason. The IMF has predicted a 7% growth in GDP for India for 2024-25, making us rank at the virtual top of the ladder. The World Bank has followed suit. Gross foreign direct investment inflows ranged at about $71.4 billion in 2023 and about $71 billion in financial year 2024. There has generally been a decline in global FDI. So the net FDI inflows, which stood at $42 billion in financial year 2023, dipped to $26.5 billion in 2024. According to our Department of Economic Affairs, India's overseas direct investment, ODI, stood at $33.45 billion in FY 2023, $51.06 billion in FY 2022, and $50.71 billion in 2021. Between April and June this year, India's ODI stood at about $9 billion. So these figures are now a clear indicator that India is not just an importer of capital, but we are exporters of capital. We today do not stand on the cusp of a country which is fearful of the inroads of foreign direct investment, or for that matter, of human capital from abroad into India, because we are net exporters of capital, both human and economic. And that's why I said that the time has come for India to take the lead in fostering a culture of international arbitration. By establishing a robust institutional framework, India can champion the growth of arbitration in the global south, promoting a fair, efficient, and reliable means of resolving commercial disputes. I'm delighted that PCA is honoring its affinity with the Indian legal system by establishing a regional office in New Delhi under the host country agreement. The office, located right across from the Supreme Court of India, is symbolic of the common goals of both our institutions to encourage arbitration and promote the rule of law, ultimately contributing to the growth of international trade and investment in our region. I am certain that this development will be instrumental in recognizing India as an arbitration-friendly jurisdiction in South Asia and would allow parties in dispute located in or near India to take full advantage of the flexibility and efficiency of the PCA-administered framework. Since the last PCA conference in 2020, India has made several strides towards embracing this role of becoming a global arbitration hub. I would like to take this opportunity to share some of these successes with the audience, particularly from overseas. A prerequisite for achieving commercial efficiency and upholding the rule of law is certainty. In a landmark decision in Cox & Kings versus SAP India Limited, a 5-judge constitution bench of the Supreme Court conclusively resolved the ambiguity surrounding the group of companies doctrine in the Indian context, putting to rest conflicting interpretations and establishing clear principles of law. The law in India on this point is now consistent with international practice. Indian law mandates that certain documents be stamped, indicating that the necessary duty has been paid to the Indian revenue authorities. In December last year, a 7-judge bench of the Supreme Court of India settled a question about the enforceability of an arbitration clause in an unstamped agreement. Initially, a bench of 5 judges of our court in NN Global Mercantile Private Limited versus Indo-Unique Flame Limited had held that an arbitration clause contained in an unstamped agreement cannot be enforced, and a referral court may prevent the initiation of arbitration until the underlying contract is validly stamped. Quite understandably, there was a furore in the investment community. The Supreme Court was quick to course correct, and a bench of 7 judges upheld the principles of severability and the primacy of arbitral autonomy. The court advocated for a hands-off approach by referral courts and held that the court is only required to examine the existence of arbitration agreements, leaving it to the arbitral tribunal to rule on its jurisdiction. Further, we held that the issue of an insufficiently stamped instrument is not fatal to the arbitration agreement and can be dealt with by the arbitral tribunal in accordance with the doctrine of severability. Not only jurisprudentially, but even while appointing arbitrators, the Supreme Court has made a significant shift beyond solely appointing retired judges to conduct international commercial arbitrations. As Mr. Fali Nariman aptly put it, we are dispelling the myth that only retired judges make good arbitrators. This evolution acknowledges the wealth of talent among young advocates and arbitration practitioners, including a growing number of women members of the bar today. I've been told by my courtmaster just this afternoon that among the 45 appointments which I've made in the last few months of arbitrators under Section 11, over 23 have been from the bar of the court, the rest being from former judges. If I'm being candid, my initial instinct on the bench was to appoint a retired judge, simply because that is the way we have always done it, a habit rooted in familiarity. But I now find myself taking a moment to pause and tap into India's burgeoning pool of skilled arbitration lawyers with the expertise, knowledge, and skills to excel as arbitrators. Ultimately, it's also a question of supply and demand, and there's so much of work being generated that there is enough for people, particularly young women lawyers, to act as arbitrators, completely displacing the gender imbalance in the world of arbitration. In fact, we are taking a step forward to not only dispel the myth that only retired judges make good arbitrators, which of course they do. I hope Indu will be pacified. Also Brother Rastogi, who is in the audience. But to further experiment with the proposition that good arbitrators also make good judges. And how is that? As arbitration gains traction as a preferred mode of dispute resolution, related litigation is increasing before the courts. requiring judges with specialized expertise. Members of the bar with extensive experience in conducting arbitrations and appearing in arbitration-related cases have been appointed as judges of the high courts in the last few years. Similarly, practitioners with significant experience in international arbitration are increasingly being designated as senior advocates by the Supreme Court of India and by the high courts. On the legislative side as well, the Parliament has initiated efforts to revamp the Arbitration and Conciliation Act of 1996. To this end, the Ministry of Law and Justice has established a committee to review the effectiveness of the Act and suggest amendments. The committee has submitted its report, which is now being acted upon by the Ministry, paving the way for potential reform. In the midst of this unprecedented enthusiasm for arbitration in India, this is an opportune moment to convene the PCA, Supreme Court of India Conference. There was a time when we were fearful of investor-state arbitration. And the reason for that was very simple. We lacked the professionalization which was required to deal with investment disputes between states and between investors and states. That environment has changed with the growing professionalization of arbitration in India. The government of India has been a very engaging partner in ensuring that we train our diplomats, not just in India but overseas, to bring a greater focus on the framework in terms of human resource development needed for pitchforking India as one of the leading participants in the international dispute resolution process. So the fears of white industries and the horrors of the early disputes have now given way to increasing success by India in the international dispute resolution framework. And nothing succeeds as success just as failures provide the occasional blip or setback. I'm hopeful that over the next 2 days, we will engage in candid and constructive discussion, tackling pressing questions head-on with the shared goal of strengthening the international arbitration ecosystem. I look forward to the ideas and perspectives that will emerge, both in the formal sessions and in the informal conversations that will take place throughout this conference. We have very distinguished judges of the high courts, experts on commercial arbitration, who have spared time to come here from different high courts to participate in this conference, because the future really belongs to them. They are the people who are going to really provide mentorship as judges of the high courts and later of the Supreme Court in the field of arbitration. And it is in that hope that we've had this talent of people from the bar and from the bench to come and work with us shoulder to shoulder in making this conference a success. I have great pleasure in welcoming everyone as part of this audience, and I hope our international guests have an engaging period in Delhi and in the Supreme Court over the next couple of days. Thank you very much.